Well, welcome back, everybody. We're going to move straight on into thinking about the trading obligation for derivatives. And Hans Wolters is going to introduce the discussion of that. Hans.
Thank you, David. For the trading obligation for derivatives, we are talking about section 311 of the consultation paper and the draft RTS numbers 11 and 12. The first RTS is on the criteria for determining when derivatives should be subject to the trading obligation, and the second one is on criteria for determining whether derivatives have a direct, substantial and foreseeable effect within the EU. I shall briefly introduce the two. The first one is basically on the description of the four criteria that ESMA will take into account for the liquidity test. As you know, there is two main factors have to be taken into account: the kind of venue test and the liquidity test. We describe the four factors that we take into account and give some feedback on the responses to the discussion paper. So we have more or less refined the factors somewhat. But it's made very clearly that the decision for whether each class or subclass of derivatives will be subject to the trading obligation is a decision on a case-by-case basis. So we have refined to some extent the criteria, but the proof of the pudding, I would say, is in the eating when the clearing obligation of one of the derivatives class really kicks in, and then the application in an individual case is done. So we are happy, of course, to hear your comments on the criteria that we propose, but the individual case should be the real test case. Also, some comments were put forward that there is, of course, a relation with the liquid market definition for non-equities, derivatives in this respect, of course. We recognize there is, of course, a link with that definition, but the thresholds, we say, shouldn't necessarily be the same. Then moving to criteria for determining whether derivatives have a direct, substantial and foreseeable effect within the EU. Well, we have linked our proposal in the discussion paper was very closely linked to EMIR, to the text there. There was, I could say, in the responses, our approach was rather supported. So we have, to a large extent, maintained this proposal, and happy to hear your views and comments on that.
Thank you very much indeed, Hans. So this is the trading obligation for derivatives section of the CP. It's section 3.11, and it covers the draft RTSs number 11 and 12. Is there anybody that would like to ask a question or offer a comment on this section? We've had a request from the camera operators during the break that if you would like to be seen, you really ought to stand up. We can hear you very well when you ask a question, but if you'd like to be seen, then you might want to stand up. So if you want to demonstrate to your boss or your association that you really were here and did ask a question, then you may want to consider standing up when you pose your question. Who would like to raise a point on the trading obligation for derivatives? There's a question in the very front row. Here we are, just coming now. Could you raise your hand again so we can see? That's it, perfect. The microphones are just coming. Just raise your hand again, please. That's it, there we go. Thank you.
Very simple question on the trading obligation.
Could you say who you are, please?
Sorry, Peter Weston, Tradition.
Thank you.
On the trading obligation, there are obviously the criteria to be satisfied, but ESMA appears then to say that it can then make a decision about whether or not to impose the trading obligation. If the obligations are satisfied, shouldn't there be a prima facie assessment that yes, the trading obligation should apply, and if it's not going to, ESMA should explain why?
Yes, to some extent, but like it said in the consultation paper, how we weigh the different criteria, that might be different in different cases. So first we have to decide what are the relevant factors to apply. So it's quite difficult to say beforehand, prima facie, it will be, the trading obligation will apply or not. As is explained, of course we use the factors, the criteria, and we explained how we are going to use them, but the decision is in the individual case-by-case basis.
So we are at this stage essentially setting out a framework or a methodology which will be applied later case-by-case with consultation and at the time in the same way as the clearing obligation for derivatives is working. Any other comments or questions on this section? Please at the front.
Ben Pott from ICAP. We welcome the recital 9, the technical standard, which effectively grants special treatment to post-trade risk reduction services and kind of takes that from the recital 27 in the level 1 text. For legal certainty, would it be, we would ask why it wasn't included in a specific article to make reference to the fact that these transactions are different in nature and therefore should not be falling within the scope of the trading obligation.
So post-trade compression services, are they caught? Well, they're not caught by the trading obligation, but the question is, should that be reflected in the RTSs to give legal certainty? Question from the lady in the red jacket at the back there.
Thank you. Maya Augustine, BNP Paribas Securities Services. I have a question for Forex in particular and the trading obligation. As you know, a provision of Forex services in the context of custody, safekeeping and securities services is an ancillary service. It's maybe a high-level question about what would you think about considering this exempt from the trading obligation when it is provided in the context of custody, safekeeping and securities servicing. Thank you.
You're talking about foreign exchange derivatives?
Exactly.
Yeah. Okay. Does anybody want to come back on either of those two questions, the treatment of post-trade services and foreign exchange derivatives when they're provided as an ancillary service to something else? Carsten?
Thank you, David. On the post-trade risk reduction services, I think we couldn't put that into this RTS because the empowerment is just to basically further specify the liquidity test. So I think the maximum we can do there is indeed put that into a recital. On the FX, I don't think that's something we have thought about before. I can't quite see how we could fit that. Well, certainly not into this RTS, but going forward when we go into the sort of real concrete trading obligation standard that covers then a particular class or subclass, maybe we can think about that point then.
So it's about the application of the standard rather than the construction of it. Any further questions on this? Yes, please. Question over in the middle there. Just raise your hand again. That's it. Keep your hand up until the microphone arrives. And I say, if you would like to stand up for visibility, you're more than welcome.
Thank you. My name is Mike Rinker from Union Investment, and I would just like to follow up on the ETD question. Article 29 of MiFIR says that ETDs should be subject to the clearing obligation. And I was wondering how that can be fulfilled, because the market practice is that only a few are clearing members on the exchange and only a few are clients connected, so to say, to the clearing member. And the practice is that market participants ask a clearing member to agree on an ETD, and so then a commission is paid in this case. So if this relationship would be seen as a derivative, one could think whether or not this fulfills the obligation to clear the exchange-traded derivative. So is it the understanding of ESMA that the current practice, how exchange-traded derivatives are agreed, or to say ordered, does this practice stop so that everybody would be required to become a clearing member or the client of a clearing member, as we know it from the EMIR part with OTC derivatives? Or do you think that if my company, for example, would ask a clearing member to agree on an ETD, that this will still be possible under Article 29 of MiFIR?
Okay, that's quite a detailed question. I'll give the team just some time to reflect on that. Indeed, they may say it's slightly out of scope of the draft RTS. Is any other questions on the trading obligation? Lady in the middle.
Yes, thank you. Elina Urgård from Nasdaq. I have a question on, or a comment on contracts which are equivalent to those traded on exchange. We would propose that under MiFID, if an exchange-traded derivative is subject to the trading obligation, it should also not be possible to trade an equivalent contract, OTC. And we see a gap here because obviously if it was possible to trade the equivalent ones outside, there is a risk that the transparency and the liquidity moves away. So I'm wondering if you've considered this.
Okay, thank you. And I think there was a question right at the back as well. Put your hand up again. That's it. Thank you.
Hi, Caitlin McLean. I'm here with Managed Funds Association. I think the issue of package transactions has been mentioned already, and our comment really was on recital 10 of the draft RTS on the trading obligation. It mentions that ESMA should assess in particular cases where the same transaction involves several derivatives, whether all derivatives traded are liquid. We appreciated that ESMA is considering package transactions in this context, but we just wanted to stress that MFA's membership considers that the liquidity of the whole package transaction should be considered for the purposes of the trading obligation. My understanding is that that issues caused several problems in the US in relation to the trading obligation over there.
Okay, thank you very much. I suspect part of the challenge is that the instrument has to apply, the obligation has to apply to instruments as instruments rather than as package transactions. So it's a good practical question. So a couple of questions around the treatment of exchange-traded derivatives and equivalent contracts and package transactions. Is there anything anybody would like to pick up in that?
Well, the equivalent transactions, I would question whether that's within our empowerment to do so, as we have to specify the criteria and to decide when it is, and decide on an individual case. So I would say it's probably more a level 1 issue. Package transaction is a question I would say we would have to look into.
Okay, so quite a number of questions around package transactions that we're logging as things that just need to be worked through in terms of how they get treated in various aspects of the provisions we've been talking about today. Are there any final questions on the trading obligation? We're going to move on to a completely different block next. There's one right at the back, I think, and we'll take this as the final question and then we'll move on.
Thanks. Gunnar Stangl, Commerzbank. There are two questions. Firstly, one regarding the classification in particular of interest rate derivatives. In the current classes of instruments approach, you have defined them to go from one tenor to the next, fact is interest rate derivatives tend to trade at standard tenors of around 10 years, 5 years, etc. So therefore actually defining classes which span a full year actually introduces certain operational difficulties when you need to decide then in which class one of the most traded derivatives actually falls. And that has a direct implication on the determination of liquidity for the trading obligation, since it's fairly sensible and easy to have a trading obligation around standard tenors as they are currently quoted. It's a lot more difficult and onerous and difficult operationally to actually introduce a similar trading obligation for intermediate tenors, in particular transactions which would frequently be linked to direct issuance and hedging transactions for primary issuance. So therefore, I would actually ask you to consider to, at least for the trading obligation, allow for a different segmentation and in particular for a focus of derivatives around those most liquid tenors. The other aspect, what you have done in the clearing obligation, RTSs, is actually introduced new definitions for counterparties. If you look across the border to Switzerland, they have actually introduced small financial counterparties very sensibly, because in some derivatives, which are in principle maybe liquid, like interest rate swaps, there are quite a few financial counterparties who maybe conclude one transaction in a couple of years. I think for those counterparties, it's completely disproportionate to actually gain access to trading venues, which they would be using every couple of years. I would therefore ask you to consider to extend your approaches to differentiate between the capabilities of counterparties, also financial counterparties, in the context of the trading obligation, and see if you could potentially introduce some of those Swiss examples also into the upcoming RTS for trading obligations. Thank you.
Okay, thank you very much indeed. That's a very helpful pair of comments. Let's move on to the next block of topics, which picks up the whole range of issues around transaction reporting, record keeping for orders and reference data. This is section 8 of the CP, but it actually covers 5 draft RTSs, 32, 33, 34, 35 and 36. And I've been joined up on the platform by more ESMA colleagues, Olga Petrenko and Julia Ferraris, who have been particularly working on these topics. And I'll start with Olga to introduce this section. Thank you.
Thank you, David. So yes, indeed, this is section 8 of the consultation paper, and these are technical standards 32 through 36. Now, these were the provisions sufficiently presented in sufficiently granular manner already in the discussion paper. A lot of technical detail were provided yet in June. So most of the changes introduced in the discussion, in the consultation paper of the December, represent fine-tuning and further clarifications to the original proposals, and not that many new requirements or articles that were not previously there. When we talk about transaction reporting, so first of all, obviously, we have fine-tuned further the very key definitions of transaction execution and transmission of the order, around which the whole concept of reporting evolves. We have provided sufficiently greater level of detail on the identification of natural persons, which obviously is one of the most complex items of this full revision set. We equally suggest going away from currently applicable MiFID approach of buy-sell indicators per transactions, which quite often cause a lot of confusion, and going into the way of reporting buyer and seller side, which hopefully is going to streamline the logic of populating report and clarifying which side has actually done what. That is on the transaction reporting. On reference data, we had a couple of options in the consultation on the discussion paper, and now have moved into very specific proposals whereby there is one submission per day of the full set of reference data on the instruments traded on the trading venue. There are no delta files, as initially were envisaged in the discussion paper. We have provided additional information on the organizational requirements, which we expect trading venues to put in place in order to comply adequately with the requirements of submitting reference data. On the order records maintained by trading venues, once again, out of options provided in the discussion paper, we have gone the route of only requiring, on permanent basis, requiring to maintain the data without specifying a particular format. And then the format conversion requirement would apply only when and if the trading venue receives a request for submission a particular part of data to the competent authority. This way trying to mitigate certain technical burden that otherwise would apply should the formatting obligation be outstanding and apply also to data which potentially could never be requested. On the clock synchronization, we have moved away from prescribing a specific reference clock and rather suggesting maximum permitted divergence rate, and also put forward a suggestion of the calibration, which should be based on the applicable latency. Maybe I will stop there for introduction. I guess this would be there are obviously further changes and fine-tunings in the text, but these are the key ones, and let's take some questions.
Thank you very much indeed, Olga. So this is really important technical material which drives an awful lot of systems implementation, both on the part of market participants but also on the part of regulators. So critically important that we get this as right as we can and as streamlined as we can. And as Olga said, we already made some quite detailed proposals in the DP that we further refined in the CP. So comments and questions on this block of issues, please. I think there's a question down at the front here. Thank you.
Okay, thank you. Dorot Bockelmann of the Association of German Banks. You just mentioned the reference data. According to Article 27 of MiFIR, all venues and all SIs are obliged to supply reference data on financial instruments that they trade. And then ESMA has to publish them immediately on its website. That's what it says on level 1. I was wondering whether it is correct to assume that this publication will be done in a machine-readable way so that the investment firms are able to use those data as a kind of golden source for transaction reporting purposes. Thank you.
Thank you. Are there any other questions on this block? We'll come back to them in groups of 2 or 3. Question right at the back.
Yes. Hello, Christian Vogt from Fidessa. I have a question regarding to RTS 34, the requirement for exchanges to store the data. One of the items there is the client ID. Can you please elaborate what you mean with the client ID, and more importantly, why ESMA asked exchanges to store that information as it is already collected via the transaction reporting? The reason why I'm concerned about it is that there are certain setups where the client ID is only be determined in the middle office after the trade was submitted to the exchange. So if this requirement will stand, then it means that either exchanges will have to provide an interface for post-trade updates of each order, or investment firms are required to enforce pre-allocation. So can you give some reasoning why you added it there?
Okay, thank you. One more question. Question from the lady in the middle here. Keep your hand up, the microphone will reach you.
Thank you. Maya Augustin, BNP Paribas Securities Services. I have a more comment than a question, and I'm happy to hear your views, and it's about the functioning of the transmission agreements for entities providing RTO services. What I would like to say is that obviously we understand the concern of the regulators to be able to reproduce the entire chain of transmission of the order until the execution. And we perfectly see that there is a big problem these days with reconciliation of the 2 legs, and with linking the whole chain back together to the initial investor. However, the transmission agreements, as they are now formulated in the RTS, would require at every step of the chain to exactly reproduce the breakdown and disaggregate the orders as they are transmitted. And we think this is really unworkable. And we think that everybody should report to the following entity to which they transmit the data they have. And the real solution for this problem would be to have a system of reconciliation of the data and not reproducing full detail of all the transactions reported. Not least because at the end of the day, the final allocation is mostly known at the level of the custodian, who will then break down between the accounts at the individual level back to the individual person. And with the very detailed obligations for all investment firms to keep records of orders they receive, if there is need to go into details of for whom the order would receive and how it was aggregated before it was passed on, is possible ex post. So when we have only 24 hours to file the full report and do all the disaggregations and also force our customers to pass the full data from back in the chain, it is really, really cumbersome to implement, and we're not sure it serves the purpose of having the whole picture. Thank you.
Great, thank you. So, question about whether the reference data that ESMA will be publishing will be machine readable. What's the purpose of having client IDs being stored by trading venues? May not be information that they have at that point. And then a comment about the how burdensome it would be to have reconciliation at each step along the transmission chain. Olga.
So maybe starting with the first one on the reference data and machine readable. Yes, the current intention is to make it machine readable, but equally as the files are expected to come from the trading venues once per day, ESMA intends to make updates to the list once per day and not on the ongoing basis in the course of the day. No real-time update. In terms of the golden source, I would caution that that is not the intention, and that is explicitly mentioned equally in MAR, Market Abuse Regulation, which has an absolutely analogical article on the reference data, whereby it said that the scope of the regulation is in no way limited by the information published in the list. We are very realistic about the potential data quality issues that might occur. We are very realistic about delays, missing data, so on and so forth. Therefore, we do not perceive this list as the golden source for transaction reporting purpose. It's a very firm reference point, yes, but it's not an excuse not to report because something was not on the list. It might be within the scope. I would like to suggest that question on the order data and client ID would be better answered by Julia.
Okay, thank you.
Yes, thank you for the question. Regarding the concern about the pre-allocation requirement, I just wanted to clarify that the intention is not to introduce a pre-allocation requirement with the order record keeping RTS. In fact, to account for these situations, we provide a solution within the RTS itself, in the sense that when the client information is not available at the moment of the submission of the order, then the aggregated flag can be used in order to submit the information and populate the client ID field accordingly. Thank you.
And then Olga has one more comment.
Yep. Sorry for jumping around, but the question about the chain and transmission. So the actual intention of the provision on the article how the transmission is to be organized is not to reconstruct the chain. It's rather different. The actual reason for it is a provision of Article 26(4), which says if all the details of the transaction relevant for the reporting purposes have been transmitted to the next in the chain, the firm itself that has made a transmission has no longer an obligation to report, because the report can be done by the next one who has got the details. And the problem we have found here is that quite often the two parties, when engaged in the transmission chain, believe that they have transmitted the details, so the other one will have to report, while the other one will not have received all the details, and he believes that the original one is going to report. In the final result, no report arrives at all to the competent authority, because there is no clear process and no clear way of knowing as to what extent the transmission has actually happened, and I am now free of my reporting obligation, or the transmission in its way as supposed to be understood for a transaction reporting purpose has not actually taken place. Therefore, I still maintain my obligation to report. So what we were trying to do with the transmission article and all the individual steps prescribed there, provide clarity for the reporting firms to know whether they have transmitted the relevant details and no longer have a reporting obligation, or they have not transmitted the details and therefore they maintain themselves the reporting obligation. That was the goal and the reasoning behind it. Please take a look at the 26.4, and this is the issue we tried to work around it. If you believe the provisions of the transmission article do not capture this intention, we are very much welcome to see your comments and further proposals to fine-tune that.
Okay, thank you, Olga. There's a question over in the bottom left-hand corner here.
Joachim Kuhn, DZ Bank. I would like to understand the present idea of ESMA regarding two general topics of the RTS 32 transaction reporting. The first would be the topic of delegation, and the second would be the involvement of trade repositories in the transaction reporting process and their application as arms. And whether the intention of the legislator is that only the EMIR parts can be reported by a trade repository, or as well equity and equity-like instruments, which would ample the possibilities of the trade repository very much.
Okay, thank you. Any other questions, comments? One over in this right-hand corner.
I read in the consultation paper that MiFID II and MiFIR is not applicable to the primary market, and there they make one exception for the self-placements of instruments issued by financial institutions itself. But when I look at the reporting part, the reporting towards the competent authority, there it is expressly mentioned that issuance and placements are not excluded. So this is also a primary market reporting obligation. And why is it so important? Because when you look at the broadening of the scope, also financial instruments which are not traded on a trading venue, but where the underlying is, or where a basket or index is used as underlying, where at least one is a financial instrument traded on a trading venue. In that case, there is also a reporting obligation. If I combine both, if you look at the share of a UCIT or an AIF, both are in general non-exchange traded. But if you look at the way they are issued, it's always a primary market transaction because it's a permanent capital increase and decrease. So if I combine both, these are transactions will be subject to the reporting obligations towards the competent authorities. And it's a huge, a volume of transactions that in the future would be subject to the reporting. Is this a correct reasoning, or is there something missing?
Okay, thank you. So we've got questions around to what extent, if at all, are primary market transactions in scope of transaction reporting, and how are baskets of transactions to be reported where some elements of the basket are exchange traded instruments and some aren't. What's the possibility for investment firms to delegate responsibility for transaction reporting, and then can trade repositories register as arms even for instruments which they are not collecting as in their capacity as trade repository? I think that last question is reasonably straightforward, that I might even attempt an answer at it, which I think the answer is yes. Trade repositories can put themselves forward as arms alongside other market participants. They're not restricted to the business for which they perform the trade repository function. But the other two elements, delegation and primary market scope.
Not sure what exactly the question about delegation is, because it was said as a topic on delegation without elaborating further. So what aspect exactly of the delegation.
Did you mean whether investment firms can delegate the responsibility? Yeah.
To give forward their details to a trade repository, if they are direct participants in a trade, or whether that trade is done by a third party with somebody else. So the constellation from EMIR that you...
You mean if the two counterparties have submitted a report, I am mentioned there in the middle because I have provided a brokerage service for that specific derivative contract when it has gone to the trade repository. To what extent trade repository can extract me from the middle of the trade?
No, not necessarily. So if the one who is reporting to the trade repository is part to the trade or not. So in our case, for example, we are the central banks of the German credit corporations, and we execute trades with them. And we send them to the trade repositories. Nevertheless, we send trades to the trade repository, which done by our primary banks with their clients as well. So would that be possible under MiFIR 2? Because the whole construction doesn't say anything about that. So that is an open issue that I've never read anything about, you know.
I'm afraid that's not going to be a matter of transaction reporting per se. It would be more a matter of organizational requirements for investment firms, to what extent and what services and or obligations might or might not be outsourced.
Meaning the market participants would be free to do so based on legal provisions they close between each other, right?
What I'm trying to say, I don't know an answer because that's not the part of the transaction reporting bit of it.
Sorry, your question has turned out to be more complicated than I had first understood, so I think that falls into the category of things I mentioned right at the outset, that it's difficult for us today to get into discussing interpretation of essentially level 1 provisions, but let's just log the fact you've asked that question, and we'll reflect on it. Any other comments or questions on this block? Yes, please, at the back, Alex. And then we've got one at the front as well. Right at the back. That's it.
Hi, Alex McDonald, WNBA again. On listing of reference data by venues, particularly for derivatives and or forwards, there is something we have engaged with ESMA on before Christmas. How is the thinking evolving? Because it wasn't clear to me from the CP for derivatives that don't have, you know, ISINs or broadly accepted identifiers, and also the multiplication of the numbers of products. I think we supplied, you know, some idea of how many products would have to be supplied to you sort of every day, and therefore recommended that we just supply delta files when new products start to trade. But when I read the CP, it wasn't clear to me if we could use categories of derivatives, perhaps the categories in the transparency framework, for instance, in the absence of those identifiers, and multiplying out by every product and every date and every day count, et cetera, et cetera. And it didn't appear that the idea of supplying delta files when new derivatives actually start to trade was taken up by ESMA either. And I just wonder what your current thoughts are on that.
Okay. So some questions around how UPIs will work in practice. There were a couple of other hands I saw, yes, at the front here, please.
Hello, this is Dougal Featherstone from Optiva. We'd like to express a general concern about timestamping with the requirement that trading firms must timestamp in reference to the latency of the venue could become very difficult for a firm for which latency is not important. If they're connected to pretty much any of the major exchanges in Europe, they would gain a requirement to timestamp at a microsecond when their trading systems may operate in milliseconds. So we find that as an undue burden upon many firms. And a question from that is, would it be possible for you to consider that the timestamps be taken by venues and that trading venues merely record the sequence of events. They take the timestamp from the venue, they receive that in a message, and then they record the sequence. Would that be sufficient to determine market abuse?
Okay, thank you. Let's take one more question before we try and digest those. One down in the bottom left-hand corner.
Lange BVR, to the same point, clock synchronization. ESMA recognizes that this requirement to have the most accurate trading venue timestamp, of which one is member of or participant, is might be disproportionate for participants and members that do not engage in high-frequency trading. It's mentioned at number 18 of the consultation paper. We would like to support, like the last speaker, your doubts about this, and we think that for a non-HFT participant or member of a trading venue, it should be ambitious enough to have a centisecond timestamp, but this should be, from our point of view, enough. Thank you.
Thank you. So, any comment on the unique product identifier approach and whether it's capable of capturing all the derivatives that are out there? Any comments on whether there's a more flexible approach to time stamping?
Taking the first two and leaving the next two to Julia. So starting maybe with the reference data and the absence of identifiers for certain type of derivative contracts. It's a given fact. ISINs, AWIs are not applicable to everyone, so our current thinking is to capture everybody else who do not fall within ISIN, AWI through the classification. Now, what kind of classification exactly it's going to be? Is it going to be the one prescribed based on market practice? Is it going to be the one detailed in the technical standard? It's still an open discussion, and it's actually one of the reasons for the question in the consultation paper, the way of identifying, you can read /classifying instruments which otherwise do not have ISIN AII. On the multiple data set for instruments, data file, and infinite range of possibilities that can be traded, but you never know what has actually been traded till the trade has taken place. We indeed considered the delta approach, we considered the categorization approach, believe both of those are not in line with what level 1 requires, and therefore the way of addressing that particular concern is Article 3.4 on page 447 that talks about a submission in these particular instances. It talks about submission of the reference data upon the receipt of order or a quote for a given instrument, assuming but that moment in time, the actual details and reference elements pertainable to that instrument become known and available. And given we are talking about submission of reference data post factum and not prior to the trading commence, this hopefully should be a feasible way forward and achievable one. If you still believe it doesn't work, we very much welcome the comments. But that was actually the reason why we introduced in the reference article the concept of specified list, whereby we try to differentiate between old school classical trading on, let's say, regulated market where there is a definite list of specific instruments traded day by day, you know exactly in advance what your trading today is going to look like, and then trying to embrace the new reality of MiFIR with introduction of OTFs and the like, where there is a possibility of trading in many different variants, depending on what exactly are the preference of a particular trade to be concluded. It's impossible in advance to submit a definite list. Therefore, the requirement would be, this would be classified as venues with non-specified lists, and the reference data submission obligation would apply upon the receipt of a specific quote or order with the relevant details. And then it was the clock synchronization?
Yes, this is take us into the theories of relativity, I guess. Yes. Julia.
Okay, thanks again for the question. So on the requirement for members and participants to trading venue to synchronize to the same accuracy applied by the trading venue, as highlighted in the paper, we would welcome feedback from the industry and the stakeholders on possible calibration of this requirement for the members and participants, specifically for non-HFT members. In terms of the suggestion to rely only on the timestamping of trading venues, I would like to emphasize that we would need also the investment firms and the member participant to apply a certain accuracy and granularities in timestamping, and that is needed for cross-market market manipulation investigation purposes. So we wouldn't be able to accommodate for dropping the requirements for members and participants altogether. However, we would welcome suggestion on how to calibrate the requirement.
Thank you. Final call for questions on this general topic of transaction reporting, reference data, trading venues, keeping orders. Question towards the back there, please. Yes. And I've got a question right over in the corner as well.
Carsten Meyer, Define. I have a question regarding the RTS 32. There you state that securities financing transactions are excluded as long as they are subject to the SFT transaction or the SFT transparency regulation. So my question is, before the effective date of the SFT transparency regulation, does it mean that SFT transactions have to be reported under MiFIR?
Okay, and then let's take a question from right at the edge here.
Stephen Travers, London Stock Exchange Group. Can I just check your understanding of the level 1 and what I interpret to be your level 2 around the use or the requirement for trading venues to pass standing data to ESMA? That's for publication to the competent authorities, not to everybody on the ESMA website. It's not specific in the level 1, but I read it as being only for sharing with the competent authorities. And that's what I interpret from your RTS.
You're talking about
the reference data.
Reference data or information about orders?
The reference data.
Reference data. Okay, thank you. So the data that's collected from trading venues, the reference data, I think that does get published, doesn't it? We were talking earlier about the question about the golden source was precisely that question. Does that go to be a component of a golden source of the reference data? It does get published.
Yes, indeed. It's first of all, there are two empowerments. That's the MiFIR reference data, and then it's Article 4 of Market Abuse Regulation, who essentially has identical text, formulated differently, but exactly the same outcome. Daily basis, there is a reference data submitted by each individual trading venue to the competent authorities, which then are supposed to transmit it to ESMA for its subsequent publication on its website. It's Article 4.3 of MAR. I'm not sure about 3, but it's 4 something of MAR, and it's the last paragraph of Article 27.1 of MiFIR. So the intention is to publish exactly what we receive from the competent authorities. And on the SFTRs, we are in rather a tricky situation here because, as you know, SFTR negotiations are ongoing right now, and they're ongoing on a rather aggressive timeline. So we still are to see where SFTR stands once we are finalizing the technical standard, and to what extent there is a clarity about the timelines of the two regimes. Do they coincide? Do they not coincide? Does one come before the other, and which one that is? Once that becomes more clear, we will be able to fine-tune further the wording around the timing and how it actually works in practice. This is just to highlight our generous intention that we do not want SFTR reporting under the two regimes when both are applicable. So we are trying to already now structure it in a way that would allow to rely on the SFTR pure regime and not replicate the same data set. Timelines is an open question, and we are very much dependent on how the discussion in Brussels go and by when they're finished.
But it's clear that the intention would be to avoid some other double reporting or some cliff edge. One question over on the left-hand side, and then one in the middle, and we'll make those the last two on this topic before we want to move on to another one. So right over on the left-hand side, please.
Thank you so much. It's Christiane Baumgarten, Deutsche Börse speaking. As regards reference market data, the German market is quite specific in this regard. The trading venues don't own the reference data. Actually, the golden source or the national numbering agency is Wertpapiermitteilung. So once you, the data set defined by ESMA is rather broad, and it's probably more than is necessary for the identification of transaction reporting requirements. Once all this data is to be published on an open website, you put us into a difficult legal situation because we're not the owner of this data. So this actually refers to the whole German market, and as regards reference market data, the European Union is quite a heterogeneous market. It's not always owned by trading venues, and this is something which you probably should need to consider here. Thank you.
Okay, thank you. Log that as a comment. And there was a question from the middle. Actually, with the lady in the red jacket, actually, sorry, it was a lady in the red jacket who I was pointing to. Put your hand up. Yes, the lady, no, further back. Wave your hand. That's it. Sorry, I'm sorry, but we'll just have to have a cut-off at some point.
Thank you very much. I appreciate. Just about the SFTRs and the problem of overlap in reporting. I mean, the issue is not only about reporting under two different regimes in parallel, but also to avoiding a situation where we have to develop an interim reporting under MiFIR and then have to switch to another one. And the point is that at the moment in time, the reporting to TRs under the SFT is probably going to be modeled on EMIR, while the template we have under MiFIR has very little to do with that. So please also bear that in mind.
Yeah, no, I think that was understood. And which is why we recognise it's an issue. I think what Olga was saying is that right now, we can't see what the precise solution is, but this is clearly an issue that needs a solution. Okay, let's stop there on that set of issues. I want to thank Olga and Julia for their contribution and invite other colleagues who are coming on for the next section, which will be about CCP and trading venue access, benchmarks and data publication and post-trading issues to come forward and join us on the platform. I'll just be a short intermission while that happens. I hope we've got enough seats for the team that are now coming to join us. Okay, we're going to start with data publication issues, which is draft RTSs 20, 21, 22 and 23. And sections 5.1 through to 5.4 of the CP. And Tim Rowe has been particularly leading on those issues. So Tim, very brief introduction.
Thank you, David. Yeah, so it's four RTS that run from 20 to 23. RTS 20 covers authorization and organizational requirements for any entity that wants to be a data reporting services provider or DRSP. To a certain extent, these requirements are modeled on existing regimes. We've not started entirely with a blank piece of paper, so hopefully people will look at them and consider them broadly sensible. There's a clear schema in there that's linked to the level 1 requirements. So, for instance, requirements to provide an organizational chart on application, requirements around fitness and properness of senior management, conflicts of interest management, business continuity planning and systems requirements and the such. There's also provisions in RTS 20 around DRSPs identifying and remedying errors in the data that they receive or errors that they introduce. RTS 21 is more technical in nature. It's really around things like machine readability of data and the scope of the equity consolidated tape and various other bits. Time accuracy comes up again, and so does source ID, so the entity from which a publisher of data has received that original information, the trading venue or APA in question. RTS 22 is the one that's really on data disaggregation by trading venue operators. So it looks at the splitting out of data according to pre- and post-trade, by asset classes, and unless an exemption applies around country of issuer, currency, auctions versus continuous trading, so on and so forth. And RTS 23 sets out who should report an OTC trade where two firms trade OTC, the basic rule being seller reports unless one party is a systematic internalizer, in which case they report. Hopefully this is all fairly straightforward, fairly technical stuff. That's all I've got by way of introductory comments.
Thank you very much indeed, Tim. So a fairly self-contained part of the CP. Are there any comments or questions on the provisions around data publication? A couple of questions over here, please. If you keep your hand up in the air until the microphone arrives, that's very helpful. Thank you.
On the disaggregation piece, Tim, we've talked about this previously. I think we think ESMA could have been more ambitious insofar as the actual asset classes by which trading venues ought to be disaggregating data. The four asset classes suggested definitely require, at least from the buy side's point of view, definitely require more granularity. So, for instance, if I just wanted to purchase ETF data, I shouldn't be compelled to purchase all equity data just to access ETF data. Mm-hmm. So I wondered if you could comment on additional work in this space.
Yeah, thanks for the question, Arjun. It's one of those interesting areas because in discussion with various stakeholders, some people have been quite keen not to require disaggregation. They argue that venues sell a tape of data and that people should consume that tape. It shouldn't have to be disaggregated, but quite clearly the level 1 requires it. Others have made your comment that actually the four broad categories we have of equity instruments, fixed income, emissions allowances and derivatives are far too broad. And I think particularly, notwithstanding your comments, people focus on derivatives and say it's a pretty broad bucket of instruments. We're very open to hearing comments here. We will take them into account as part of reviewing this particular RTS. Right at the moment, I'm just open to any comments that stakeholders want to make.
Thank you. And there's a further question over on the right.
Stephen Travers, London Stock Exchange. This is less a question, and it's probably one, well, it's a question for you, but I'm not sure you know what the answer is. And I don't think any of us do.
Yeah, okay. Business as usual, then, Stephen.
Yeah. Well, and for the broader panel, in terms of the organisational requirements for the consolidated tape provider and the APA, fine, I think we recognise those from trade repositories. My question is, what exactly is the consolidated tape provider going to be doing? What's its business model? How on earth is the industry going to put one in place in time for the ESMA review if it doesn't know what it is? Now, it may or may not be ESMA's place to describe that, but the Commission isn't particularly describing it either, other than saying it's all equities, all countries from day one, apart from 3 months. That doesn't really help, in my opinion. I don't know what others think, but it doesn't advance the position at all. And I think the industry needs some help with this, because there's no point in someone coming up with something that is low latency, real time versus 15 minutes free. They're two entirely different business models. We don't want to waste money at this difficult time building things that people don't want.
Just to be clear, Stephen, what is it you think is unclear? What is an acceptable CTP from a regulatory point of view, or whether people can make money with different business models? What's unclear?
For me, what's unclear is what's the purpose of the consolidated tape? And everyone you ask has a different view. So is it for TCA? Is it for immediate regulatory supervision? Because those two things would change the dimension of how delayed it was, for instance. So that will affect whether people say, well, then I need to be collecting and aggregating all the data immediately and distributing it as quickly as it's coming out already, or I can do it using the 15 minutes free delayed tape. It's an entirely different business model.
Mm-hmm. Yeah, thanks, Stephen. To be honest, all the way back to when this was first being negotiated at level 1, we were having conversations with stakeholders who were asking the question, you know, what is the use case here? What is this supposed to be for? Yeah, there's nothing in the MiFID II construct which prevents trading venues from continuing to sell a direct feed of data. So you know, it probably is a reasonable argument to say there are an awful lot of participants who will choose still to consume a direct tape from a venue. They will not use the consolidated tape provider. Similarly, you know, there will be effectively the 15 minutes delayed data, which is for a lot of people a reasonable source for tape of record, best execution monitoring, research purposes, or whatever. And you know, the tape is useful for surveillance purposes, but that, I don't think, was its primary function when it was originally conceived. It was supposed to be something that people could use for trading purposes. That would mean, I think, there is a space where the consumer group would be those who want to use a tape for trading but are not overly latency sensitive. Whether that group is sufficiently large to support the operation of a consolidated tape, I don't know. I've had a number of people say to me they don't think that's possible. Against that backdrop, it's perhaps challenging as well that the tape has to take all the trades, and it is equity and equity-like instruments as per the the scoping out in the RTS, which was done in part with input from the Commission. So I can't really add anything further than that. It's got a space, I think, but whether that's a commercially viable space is really for us to work out in due course.
Okay, thanks, Tim. Any other comments or questions on the data publication? One in the middle.
Elena Rugård from Nasdaq. I would underline some caution on too granular disaggregation, and I would highlight specifically 2 reasons for this. One is that the vendors to who we provide the data do not request or demand disaggregated data. We could, of course, disaggregate the data. It would come at a cost. We believe then that the vendors would have to re-aggregate it again because of demand from users. So there would be extra costs at our level and also further down the value chain from the vendors. And this doesn't seem to help lower costs of data. And the other reason is that when we provide aggregated data, we include, for instance, both big and small shares. If we would disaggregate the data, there would be much less, or the demand would be for the big shares, and fewer would demand the data from the smaller shares. And today there are many people working, trying to make the smaller companies, smaller listed companies' data more visible. So by having it aggregated, we believe that helps visibility for smaller companies. And also, if we would disaggregate it, the fee that the users would pay, I mean, taking away the small companies would probably not reduce the costs also. Thank you.
Okay, thank you. Any other comments or questions? One from over here on the right.
Thanks. Just to respond to what was just said by Nasdaq, I mean, the demand argument is something that's been going around for quite some time, and it's a chicken and egg argument. I mean, if we are provided with further disaggregated data, we will purchase it. We are now demanding for, there is demand, at least amongst buy-side firms, for further disaggregation of data. Yet we're not being provided, our demand is not being satiated by supply. And the idea that buy-side firms, we we manage money on behalf of Europe's investing and saving citizens. And the fact, and the argument that people with pensions have to pay to try and raise the profile of private sector companies, to us doesn't necessarily make a lot of logical sense. So both arguments we think have no merit in them at all.
Okay, thank you. I think if you were here at our open hearing last June, you'd have heard a very similar conversation between exactly the same two people about exactly the same topic. Over on the left-hand side, please.
Yes, Christiane Baumgarten, Deutsche Börse again. As regards disaggregation and the recent comment, I would like to point out that as of today, exchanges already provide quite a lot of data, be it for free or be it sort in a way it can be easily consumed. For example, there was a discussion about auction data, I think on a recent FCA event, where the buy side pointed out that they would need to have auction data unbundled. Why do they need auction data? And I appreciate this is for the purpose of mark-to-market or for actually having intraday and end-of-day evaluations. If they take the 15 minutes delayed data, is my understanding, which is free of charge by the exchanges, they should be absolutely fine in achieving what they want. And I would recommend to have a look at all the license terms already out there for data users in a more detailed fashion and to see what can be achieved by what is already available.
Okay, thank you. If there are no other comments on this section, sorry, there's one final question. Let's take this as the final question on data disaggregation.
Thank you. It's Kerstin Hermansson from Sweden. I just wanted to comment on the discussions in relation to disaggregation of data. I mean, there are also other solutions. If the exchanges prefer, they could also sell the data aggregated at a cost, and then others would probably be prepared to disaggregate the data at a market price, reasonable commercial basis. Just a comment, more than a question.
It's always good to end on a comment rather than a question. It means we can move on to talking about access to CCPs and trading venues and benchmarks. This is draft RTS number 24, and it's sections 5.5 and 5.6 of the CP. And again, Tim has been particularly leading on that.
Thank you, David. So RTS 24 is a single RTS covering all the provisions, level 2 provisions under Articles 35, 36 and 37 of MiFIR. You will note, or you may have noted, Article 1 of the RTS sets a kind of a clear principle up front, which is a principle we're taking directly from the level 1, which is that a recipient of an access request, a trading venue or CCP, should be making all reasonable efforts to manage any risk it identifies, and it's only if it remains with what it considers to be a significant undue risk can it turn down an access request. This is to try and reinforce the level 1 provision that access is what's supposed to happen when a request is made, and it's only if there are unmanageable risks that those access requests should be turned down. The rest of the RTS kind of chops up into some chunks, at least in terms of the way we've thought about it and approached it. Denial by a trading venue or a CCP of an access request is really covered between Articles 1 and 6, and it looks at all the other bits and pieces as well, impact of additional transaction volumes, operational risk and the such. Denial of an access request by a national competent authority on the grounds of a perceived threat to the smooth and orderly functioning of the market is covered in Article 7, and conditions for granting access, so the contract terms or constraints around contract terms and non-discriminatory fees is covered in Articles 8 to 10. So we've tried to go through saying, here are the bases on which you can turn down an access request, and here is the basis on which you have to be fair if you decide to grant the access request. The issues around collateral netting, cross-margining, I know have elicited a lot of interest. They're covered in Articles 11 to 13 and cover things like what is the notion of economic equivalence. And when we get to that point, I'll look to some of my post-trade standing committee colleagues because that's one bit that hasn't been covered by the task force that I coordinate. Article 14 through to Article 19 covers the transitionals for those venues and CCPs that choose to opt out on a temporary basis from the access provisions. And then the licensing of benchmarks, which is all the bits related to Article 37 of MiFIR, are covered in Articles 20 to 23, cover things like the information to be made available by the benchmark provider, and indeed the principles guiding how we might judge a benchmark to be new. That's in Article 23. And this has been particularly tricky for us to frame, but we've tried to set out some ideas that you can look to help judge whether an index is new or when it might be less likely to be new, as we've phrased it. They're my introductory comments.
Thank you very much indeed, Tim. I guess these RTSs support elements of the level 1 which are designed to encourage and promote competition in the trading and the infrastructure space. But we have tried very much to make sure that we stay within the mandate, particularly on the access provisions, where the mandate is to really try and identify the circumstances in which the undue risk criterion might be triggered. Does anybody have any questions or comments on this batch of RTSs around access and benchmarks? Stephen in the corner.
Thank you. Stephen Travers, London Stock Exchange Group. We're supporters of access, and we applaud the approach that ESMA has taken, that Tim's outlined. I guess our question, more directed to the colleagues that he mentioned who are here from the post-trade group, is we've got concerns about how effectively the definition of economically equivalent works, given that it, to my mind at least, mixes the concepts of fungibility and therefore identicality of contracts and correlation, which is a measure of economic equivalence. Are you open to suggestions that might give a little more granularity around that in order to avoid having too many broad sweeping statements that could then entitle someone to use those as a way of rejecting an access request?
Okay, I think we're going to come on to that as the next topic, so perhaps I'll just put that to Gianpiero just to reflect on, and we'll pick it up as we pick up the next segment. Let's just hold that thought then. Any other comments or questions on access and benchmarks? No? Okay. Well, let's move then on to batch of post-trading issues, which form part of this CP around straight-through processing, indirect clearing, and some the economically equivalent concept. And Gianpiero is going to introduce this, and then we'll take some questions and comments. Gianpiero.
Well, I can answer the question, but it's my colleague that will introduce the next session.
Okay, well, let's take the question, answer the question, and then we'll come up to the next.
Yes, so of course we are open to take into consideration also other type of definition, and this the purpose of the consultation process. So if you have any proposal, we are happy to look at that. The approach that we followed was to have a very open definition, not to have a deterministic definition of economically equivalent contracts. And this is because any type of deterministic definition will look at the situation today will not be able to capture any innovation in the future. And looking at the issue of distinction between economically equivalent contracts and correlated contracts, where the correlated contracts are already defined under EMIR, and we thought that there was not need to make in this type of RTS a distinction between the two definitions. So I hope that I answer your question.
Okay, thank you. I'm slightly getting ahead of myself there in terms of the post-trading issues. This is draft RTSs 37 and 38 and section 9 of the CP. And I'm very pleased to be joined by Emmanuel from the ESMA staff to come and introduce that section for us.
Thank you. So a brief introduction of the two RTS. The first one is on straight-through processing. We've taken on board all the comments from the discussion paper, which were really stressing the need for certainty of clearing at an early stage and as much as possible before trade execution. So that's one big component on how we've set up the requirements. And the second was on getting. We get a lot of feedback on the actual numbers in terms of the details of the timing, which you can see in the proposal. And thirdly, the respondents stressed the distinction that needs to be between the different cases that are in scope under this RTS, so whether it's traded on a trading venue or not, whether it's voluntarily cleared or not, etc. So the RTS is broken down into these different cases, and these are the requirements throughout the process, from execution to a clear status of the trade. So this is for the first RTS. For the second RTS, it's about indirect clearing. Several respondents highlighted the fact that there's a lack of indirect clearing services for OTC derivatives, highlighted a few issues, some of them on which ESMA doesn't have any leverage, but some of them which were attributed to some of the provisions in the RTS under EMIR. And we've tried to tackle these and bring forward a proposal for consultation to address some of the concerns around the operational burden, as well as some of the legal concerns. So the proposal is articulated around a new and alternative set of segregation arrangements, a net omnibus, which was the case in the previous in the discussion paper, and then a new gross omnibus structure, but with a set of additional requirements which together aim to achieve an equivalent effect of protection with regard to the positioned assets of the indirect clients, and to mirror the requirements under EMIR. So these are the two RTS we can discuss today.
Great, thanks so much indeed, Emmanuel. So comments and questions on the post-trading block of issues then. Question at the back, on the right-hand side.
Adam Jacobs from AIMA. An observation on the STP provisions. I know that the prospect of voiding of trades that fail to clear is not universally popular, but we certainly think it is necessary to ensure discipline elsewhere in the process for straight-through processing. I would flag, though, that I limit that comment to the OTC space, and we do recognise, and I think there's a fairly strong consensus that what is appropriate for OTC derivatives is not necessarily appropriate in the exchange-traded context.
Okay, thank you. Other comments or questions?
Alex McDonald, WNBA again. Just one comment. We would endorse the segregation or classification of self-clearers from other clearers, i.e. those firms who have direct memberships of clearing CCPs, such that they don't need to pre-post margin onto trading venues themselves, because the guarantee of innovation is there. I think that ESMA's aware of that issue anyway.
Okay, thank you. And I think there's a question at the back as well.
Hi, Caitlin McAlane, here with the Managed Funds Association. We heard a few technical comments, which we will make in our response, but they're generally around the need for flexibility in the drafting of the RTS. So just by way of example, there are various means we understand by which pre-execution credit checks can take place. So the regulatory technical standards contemplate a situation where the clearing members pushes its limits onto the trading venue. The trading venue then checks those limits. But there are other options for pre-execution credit checks. So, for example, the trading venue could go and ask the clearing member by pinging it to accept an order, or you could have a credit limit hub, for example, that sits between the clearing member and the trading venue and effectively replaces direct communication between the two. So there are a couple of points like that on clearing member credit checks as well, I think, where we just like to see a bit more flexibility for different approaches to clearing in that context.
Great, thank you very much indeed for that comment. Anything else on this strand? Over here again.
Sorry, Stephen Travers again. I'd endorse that because I think that what we don't want to do for the pre-execution checks to get in the way of the low latency, the HFT, all the things that we've built systems for at the beginning of MiFID, it would be foolish, I think, to undo them. So some flexibility in how they're exercised. I've got a broader question which has been occurring and in discussions with others across the industry, is that, of course, whatever a trading venue knows, or even a CCP, about the activities of a particular client are only related to what they know, and I'm not quite sure the extent to which you're thinking that these checks are market-wide or just in relation, obviously they're just in relation to the trading on that venue, but that's quite a big issue for the investment firms to manage, or the clearing members, as to how, whether they're supposed to be regulating the overall credit position of a client, or whether it's just obviously vis-a-vis the particular instance. That's all they can do, but it's a bigger question. I'm not sure whether this really addresses it.
Okay, thank you. Emmanuel, Giampiero, have you got any final reflections as we close this? I don't think anyone's actually asked a straight question, but a number of comments that you might want to respond to if you like. You don't have to.
We've been made aware of this issue of the flexibility on the pre-execution checks in some bilateral conversations. It's definitely one of the topics that we are looking into, and we are looking forward to your comments. What I would suggest is that if you are going to propose flexibility, it would be good that you propose how that flexibility should be described. Otherwise, that would facilitate our job.
Okay, thank you. Thank you very much indeed, Emmanuel. Thank you very much indeed, Giampiero. Carsten, I wonder if you could come back up to the stage and we'll just bring forward one topic that we might have taken this afternoon and just clear that out of the way before lunch. And then we'll take a break. So this is the next item on the agenda, which is the issues around suspension of instruments and other organisational requirements. It's draft RTS 25 and 26 and draft ITS 27, and it's section 6 of the CP. And I'm slightly taken Carsten by surprise because we were going to take this as the first item after lunch, but I think we've got time to take it now. So, Carsten.
Thank you, David. These are relatively straightforward topics. I remember when we discussed them last year in the first hearing, there was already very little comment on it, and also in response to our discussion paper, there was wide agreement with what we were doing there. So first of all, on suspension and removal of financial instruments from trading, MiFID imposes a pretty complex system there of publications and communications around of suspensions of instruments. And one rule that MiFID imposes there basically says you suspend a share, then you also have to suspend related derivatives, and we're defining here, that is RTS 26, I think, what a related derivative is, and basically we're saying, well, if this share that has been suspended is the sole underlying of the derivative, then that derivative automatically has to be suspended as well unless there are special circumstances. And that was not controversial at all, I think, that proposal in the discussion paper. On admission to trading, again, a lot of consistency there between discussion paper and now our draft technical standard. On admission to trading, I would have one request, particularly to the trading venue representatives in the room, because there we have 3 different empowerments. One is general admission requirements, and the other one, the 2 others are verifying of issuers' compliance with obligations under European law and to facilitate the access of information to that has been published under European law, and those are both obligations on regulated markets. Now, slightly complex genesis of these provisions. I think there are a remnant, basically, of times when we didn't have very detailed rules on the prospectus directive, on the transparency directive. The rules already existed in MiFID 1, and at the time there was already level 2 empowerment, but level 2 never happened. Now that level 2 empowerment has been changed to an ESMA technical standard, and of course it says ESMA shall develop rules there, and of course that's, if the co-legislators ask us to do this, that is what we're going to do. In the discussion paper, we ask about best practices existing in the markets about this, and there was no feedback whatsoever. So I would really ask the trading venues this time around to look at the proposals there and give us feedback. I know these are not the most fashionable subjects, certainly in the overall MiFID universe. The third one is supervisory topic, certainly, that is about MTFs and OTFs and their main features. That is RTS M27, and there we have put together a list of requirements which then MTFs and OTFs have to tell us about their main features when they apply for authorization or when there are main changes. That, by the way, is an implementing technical standard, so what means it has a slightly different deadline, and that's why we have introduction.
Thank you very much indeed, Carsten. Again, as Carsten says, another section of the CP which is dealing with some more nuts and bolts or operational type questions, but I'm interested in if anyone has any comments or observations on this section. I think, as Carsten says, we've been trying very hard to generate some interest in this topic for the last 12 months and obviously not completely succeeding. No comments whatsoever. Okay. Well, what I suggest we do then is we reward ourselves with a lunch break, and we start again in here at 2 p.m. Promptly, please. So I suggest you aim to come back around about 5 to 2 to enable us to start at 2 p.m. promptly. This afternoon's agenda will switch to thinking about microstructural issues, some issues around organizational requirements, particularly for investment firms doing algorithmic and HFT, market making, tick sizes, and so on. And then was also the batch of issues around commodity derivatives and then investor protection. So back here for a 2 o'clock start, please. Thank you.